Hi, this is Sarah Hobson. I am the founder of Hobson and Hobson PC. We are a divorce and custody law firm located in Marietta, Georgia. And here at Hobson and Hobson, we protect parental rights and fight for fair financial futures for those who are going through a divorce or trying to modify a prior divorce or custody action. Today I have Judge Michelle Homeyer with me. I figured in light of everyone doing shelter in place or stay at home and not being able to go out to many public debates, I thought this would be a great opportunity for the voters in Cherokee County to get to know one of the judges that is going to be on their ballot. Early voting has already started, but I thought this would be a great opportunity for you to really know who you're voting for. Thank you so much for coming on here, Judge Homeyer. I wanted to ask you some questions. So you have been a judge in Cherokee County on the bench for the past 7 years. I wanted to ask you, why did you initially want to become a judge, and what were you doing prior to becoming a judge?
Right before I became a judge, I was an assistant solicitor. I started working in Cherokee County as an assistant solicitor in February 2008. Right before that, I left the Fulton County Public Defender's Office, left there on a Friday, started at solicitor's office on a Monday. By the time the 2012 election was rolling around, it was an open seat. I always think that open seats are kind of the place you should go into. Especially my predecessor had been on the bench for a couple of decades. It was a nice chance to go that route. The reason I decided to run for judge is because I've been working in the solicitor's office for 4 years. I'd been into, at that point, we had 3 different judges. There were things that I saw that we could do differently and that I wanted to do differently than we were doing. Particularly starting in 2008 and still dragging into 2012, we were in an economic downturn. We weren't really giving people the option of community service to work off their fines until they had come back to court 2 or 3 times. One thing I wanted to do, and I do, is ask people realistically on the front end whether they can pay their fine. Because if they aren't ever going to be able to pay their fine, let's go ahead and do community service on the front end. They have to come back to court with approval. There's only one time coming back to court. It saves court appearances, it saves clerk's time, it saves solicitor's time, it saves judge's time, ultimately saves taxpayer. That's one thing I wanted to do. Another thing, we were seeing a lot of cases with mental health. I wanted to make sure that we were addressing the mental health issues. They affect, doesn't just affect one cross-section of the community, can affect any cross-section. We were seeing it no matter the type of cases. I want to make sure that we address that. Also at the time, approximately half of our DUIs coming into the county were second or more DUIs. So I thought we might be doing something. There might be easier ways to go about handling a first DUI so that we could try to prevent that second DUI.
Right.
So one of the things I wanted to do is start requiring treatment earlier rather than later, instead of just saying do a substance abuse evaluation, but do a substance abuse evaluation and then start your treatment within X amount of time. Typically, out on the bench gives, say, 10 to 30 days to start it once your evaluation's back. And then if you don't start in that time period, I see you much sooner than I would have, say, 8 or 9 or 10 months into your sentence saying you've never done your treatment. Which if they asked for, say, 2 months worth of treatment and you only got a month and a half left.
Right. Right.
So those are the 3 reasons I chose that I wanted to do and why I chose 8 years ago to run.
What I really think too that really sets you apart from other judges is that, and other people that are candidates, they're running to be a judge, is that you have experience on both sides, right? You have prosecuted cases. You have also been a defense attorney, and that perspective, I think, is so important to having a good, healthy judicial temperament when people are coming before you in court, where you're not treating them like another statistic or another failure, but you really take the time to really see what can we do to get to the cause of what brought this person into court, why they were arrested. And that's something I've always enjoyed practicing, and while practicing in front of you is um, when I'm defending someone who's been charged with a crime, with a DUI or a drug charge. I really felt that you took the time and you really appreciated and incentivized treatment, whereas other judges I've been in front of, they just care about let's just impose jail time, and there wasn't really that moment of, hey, what can we do for this individual to try to really incentivize them to not be coming in front of you again, to get their life together and to get some help. Why, what do you think has led you to not take like a cookie cutter approach to being a judge?
Because each case is different. When you come into the courtroom, you've got the same judge. I've seen well over 10,000 cases. Generally have sometimes the same prosecutor. Right now often have 3 prosecutors in the courtroom. So there's a third chance each case is gonna be on the same prosecutor. There's only a certain amount of police officers and deputy sheriffs in our county. You're gonna see the same. But what is different is the facts of the case and the person who's standing in front of you. So if I give the same type of justice, same type of sentence over and over again, and don't get me wrong, some of them, like DUIs or other cases, have some mandatory things. But if each one is not tailored, then it's not addressing why the person actually came to court. It's not looking at the particular facts. A first DUI that's a 0.085 or 0.09, something different than a first DUI that's a 0.32.
Right.
On a 0.32 case, I generally ask what happened. You don't get to a 0.32 without a significant amount of alcohol. Let's figure out what is happening. Sometimes and oftentimes it can be a substance case. But I remember one case where an individual was charged and arrested for DUI, 2 DUIs in a very short period of time. He was in his 60s. It never had an arrest before. What happened? What led us to that point?
Right.
His wife died of ovarian cancer. So that's what led us to the point. So yes, there was a DUI. Yes, we had to sentence him. But let's pay a little bit of attention to what's going to help him the most. I had to sentence him to a substance abuse evaluation, but honestly, some personal counseling is as important in that case, because processing the death of a spouse, especially after a traumatic illness, something you got to address too. Right. I've seen DUI cases that are self-medicating on mental health. Just giving some standard substance abuse help isn't going to address what actually caused it. I've seen forgery cases where they're passing bad checks that was a drug problem. If I don't ask those questions and figure out why you took somebody's checks, what you were going to do with the money, and add that substance use evaluation and treatment, is going to happen again. Because if they had a drug problem and that's why they were stealing, using marijuana, or committing some kind of crime, I have to address that, whether it looks like from the front end that that's what caused. I also have 3 children. I've got 1 son, I've got 2 daughters. Each child is completely different. What works for one child doesn't work for the other. The same thing in the criminal justice system. I can take TV away from one child and it would devastate them. I could take TV away from another child, even for the same offense, doesn't matter. That's not important to them.
Right.
If I don't do the same thing in the courtroom, it's not going to have a difference.
Right. And I think, I wish more judges would take that approach, because it does take a little more time. I understand you're trying to get through your docket each day in a timely manner, but it does take a little more time. But, when I am defending someone who's been charged with a crime, I really don't want them to come back to me as a client, right? And you really don't want them to come back in front of you as a defendant. That's not the goal. The goal is to really add more value than just seeing them through or pleading them out to a charge and giving them this, getting the standard, punishment. The goal is to really go above and beyond and really help them make a difference. Like, that's why I enjoy practicing as an attorney and helping people. And I'm sure you get the same satisfaction when you're making sure that the underlying issue is being addressed.
That's the whole goal, is to return people, to make them productive members of society again. It does give me a great satisfaction. Some cases, not DUIs, but some cases are eligible for either first offender or conditional discharge. It gives me great satisfaction at the end when I sign those acceptances of those conditional at the end of their probation sentence. They haven't come back. They haven't had a revocation. That person's been returned, and hopefully will continue to be a productive member of society. To have a DUI that, I never see again. I've seen people in the public that says, "Oh, don't you remember me?" I'm sorry, don't. I've handled thousands and thousands of cases. If you don't come back to me, that means we've done our job. The criminal justice system has done our job. They may remember me, they may remember the prosecutor, but if I don't remember you or remember all the facts of your case, it's because we've done our job. We haven't seen you back on a revocation. You've done well. We got your attention. We gave you an appropriate sentence. We're not going to see you back.
Right. And I think that's how we really keep, our community safe. What other types of cases, for people so you're running for, you're the incumbent, you're a candidate again for state court judge. What types of cases does a state court judge hear for people that may not know?
On criminal side, we handle misdemeanors. Most people don't realize every single traffic ticket in the state of Georgia is a misdemeanor. Anything from a seatbelt ticket, the hands-free law device, open container, speeding, reckless, anything you can get a traffic citation is a misdemeanor. There are a few, like seatbelt ticket, open container, and hands-free, they can only have a fine. Every other misdemeanor can have up to 12 months in jail, can have $1,000 fine. Some of them can even have $2,500 or $5,000 fine, depending on what their statute says. Though, in addition to traffic tickets, the other types of misdemeanors can be some domestic violence cases, DUI cases, shoplifting, some kind of forgery or theft up to a certain amount, possession of marijuana. Also, every single hunting or fishing violation issued by the DNR is a misdemeanor. It comes through the court. So I see everything from a seatbelt ticket to not having enough life vest on your boat, fishing without a license, to a DUI. There's also misdemeanor vehicular homicides as well. On the civil side, state court can try any type. It has jurisdiction over any type of civil case except for divorces, title to land, or equity. Equity is where you're asking someone to do something. You're asking the court to issue them to do an act instead of asking for a monetary award. So we can handle credit card debt. We can handle debt on some kind of other loan. We can handle civil cases where someone was in a traffic accident, medical malpractice. We can handle, there's also civil assault, civil battery, civil criminal trespass. We can handle almost any kind of civil case you can imagine, except for those three.
Okay. So, and about domestic violence. So, is any charge for domestic violence a misdemeanor, or do some charges rise to the level of a felony?
Some charges do rise to the level of a felony. Depends on the type of injuries. If they're more significant, they can be charged with felony charges. Depending on the person's criminal history, some of them get automatically elevated to a felony regardless of what the injuries are. Some of them are, we think of them as domestic violence, but the law doesn't classify some of them as domestic violence. The brother and sister are not always considered the same, but it may sound extremely terrible, and it certainly would be extremely terrible if you're a victim or a witness to domestic violence. But depending on the type of injury and the person's history, sometimes they're misdemeanors and sometimes there's felony. Serious broken bones, serious disfiguration, a broken nose or broken jaw, strangulation, those are felonies. What we usually see in state court is what we call battery, simple assault. Some of those don't even involve a physical injury. Some of them just involve being scared that you're about to receive a physical injury. You can also be charged with disorderly conduct, which is where you're acting in a violent or tumultuous nature to someone, again, with the idea that they not really sure what's happening in the situation. The victim or victims are extremely scared of what will happen. They're not necessarily thinking that, maybe they're going to get shot or hurt, but they're not really sure. It's an unstable, chaotic situation. Those are the type of domestic violence I see in state court.
So a felony would be heard by a superior court judge, it's a different court, a different
class of court
entity.
Yes.
Okay. And there's also other types of misdemeanors that may rise to the level of a felony, like if you have a certain amount of DUIs, at that point it becomes a felony, right?
Right. Your fourth DUI in a 10-year time period can become a felony. Your fourth driving with suspended license in a 5-year time period can become a felony. Same with no license. If you had a certain number of shoplifting cases, regardless of the amount, once you get to a certain number, it can go up to felony. So it's not necessarily the value or sometimes it just depends on someone's history as to how it gets elevated.
And there are certain laws that tell you what type of a negotiation you can accept between a prosecutor and a defense attorney, right? There's a spectrum that it must fall into for it to be the sentence that you can impose.
Correct. Generally, as I said, most misdemeanors are up to 12 months in jail and $1,000 fine. However, there are others that require certain things. DUI has to either be a probated sentence or a straight 12 months in jail. If it's a probated sentence, there are certain requirements, such as mandatory amounts of community service, mandatory substance abuse evaluation, mandatory victim impact panel, other mandatory things, and how much or what all is required depends on the number of DUI that you have. Go ahead.
Oh, sorry. I was going to ask also, how many cases so when a case comes before you for resolution for, we're not talking about a trial, but, how many, most cases resolve, I'm correct in saying this, I believe, most cases resolve via plea, meaning that there's not a trial. And how many of those are, just, I'm not going to hold you to it, but just a guess of how many are a negotiated plea, meaning that this is what the prosecutor who's prosecuting the case has reached an agreement with either the defendant or the defendant's attorney as how to resolve the plea. And they present that to you to make sure that you're okay with that, you're willing to go along with what they've worked out. How many are resolved that way versus a non-negotiated plea where the defense attorney and the prosecutor do not agree? The prosecutor may want one thing and the defense attorney doesn't feel that that's appropriate. What is the makeup that you on the case that you're
I can't tell you whether it would be 8 out of 10, 9 out of 10, but it's an extreme majority of cases that are negotiated. Sometimes those negotiated cases involve what we call a cap or a maximum, meaning that the prosecutor wants X, the defense attorney thinks it's different, but the prosecutor and defense have agreed that I will give no more than what the prosecutor asked for. By law, if it's a negotiated, whether it's with a cap or a straight negotiation, if I don't go along with the negotiation, if I don't believe that that's appropriate and I give more than what has been negotiated, the defendant has a right to withdraw that plea. I can certainly give less. There are also certain times where I do not agree with either side. they can do a non-negotiated plea. The prosecutor asks for one thing, the defense asks for another. And I don't think either one is appropriate. I don't think maybe they have addressed the underlying issue. I think something different about the facts. I ask questions of the defendant that maybe someone else didn't think to ask. There may be other factors that maybe the attorneys are not aware of, particularly when it comes to probation revocations. If I've seen someone before, generally, I'm going to remember what they told me the first time. Because when I see their face, I might not remember their name, but when I see their face, it jogs my memory. And if they told me a particular situation, I'm going to remember it. I also have in front of me the paperwork from all the other times. So if I, unfortunately, sometimes on a small number of cases, I see someone back a second time or a third time. If they tell me something that second or third time that was not consistent with the first, that sets off red flags in my mind. The attorney representing that defendant may not know that information. They may have only be representing for a very short period of time, even may only have spoke to the defendant that morning as a free attorney for about 30 minutes or less. So they don't have access to the clerk's file. They don't have access, obviously, to my memory. They may not think to ask, what did you tell the judge last time? Because she's going to remember. There have been plenty of negotiated dispositions in those cases or in other cases where I'm like, that's not what I'm going to do. I'm going to do this.
Right.
There's been plenty of times after even a trial, sometimes there is a recommendation from the prosecutor after a trial. The defense said, that sounds great to me. I'll consent to that. That's not what I get. I've given in several cases, more than is imaginable, a harsher sentence after trial because I've seen the evidence and I have a different opinion of what the evidence was and what I think is an appropriate sentence.
Right. So when you're presented with a negotiated plea, there is perhaps, I mean, at this point you've not heard any evidence other than the factual basis for the plea, where it'll be presented to you that the person did such and such on such and such day, but you may not know any other circumstantial evidence, any other mitigating evidence that even maybe would come out at trial. So when a prosecutor is presenting you with a negotiated plea that he's worked out with or she's worked out with the defendant or the defense attorney, it could be risky for you to not accept it, being that you don't know that if this does go to trial, perhaps there's evidence that there could be a lengthy trial, and perhaps there would be some evidence that would come out that would not result in a quick resolution or result in this person getting help.
Sometimes cases are resolved by a plea because everyone, both the prosecution and the defense, say this is about a 50-50 shot either way. So the defendants agreed to plead guilty. We're recommending this. Sometimes because it is a 50-50 shot. Trained attorneys, I have some prosecutors that have been practicing in my courtroom for more than a decade and a half, that say I've done a ton of trials and this is 50-50. I get a very, very small snippet of what a case is about when they enter a plea. At trial, we hear all the evidence that the prosecutor chooses to present. For instance, in a DUI plea, I may hear only something like the defendant failed to maintain their lane, the officer pulled them over, they smelled of alcohol, they did some field sobriety, he agreed to take a state-administered test, and this was his level. That's all I hear. At trial, though, if that case had gone to trial, and several cases in similar situations do, I might hear the 911 call. I might hear the 911 caller testify and talk about how egregious it was. I might hear the 911 call itself going, he just went over the line here. It's been 50 more feet, he went over the line there. Oh my gosh, he almost hit that vehicle. I can hear mitigating but I can certainly also hear aggravating as well. You don't hear either side of that in a negotiated plea. Because that's the reason people have done a negotiated plea. They've gotten together, the attorneys have exchanged their aggravating, mitigating circumstances, and they've come to a resolution.
Right. And so as a judge, it is probably important, if you're just being presented with this, this snippet of information on this case, to give deference to the attorneys that have worked it out, particularly if you're aware of their reputation, they're in good standing with the court, they're a member, good standing member of the bar. And so part of it, you kind of have to trust them, right? That they are really, they're trying to resolve this in a way that is protecting the defendant's rights, that there is a factual basis for the plea, but also that you trust their professional judgment that this is the best way to resolve it.
Right. Unless I ask the defendant or have some inclination that something else is going on that somebody hadn't thought about, they are the ones who have investigated the case. When most people don't realize, but what's in the clerk's file does not include any evidence from either side. I don't have a video. I don't have a police report. I don't have photographs. I don't have any of that evidence. The attorneys are the ones who have the evidence. The attorneys are the ones that know which evidence is going to be admitted to trial and which is not, what might be problematic, what might not be. They also know if there's any problems with any potential witnesses, whether maybe they gave a statement one time and a statement a second time that isn't consistent. They know the general idea, and the attorneys that practice in front of me have done multiple jury trials, especially in the same jurisdiction. They kind of have an idea of what the jurors may or may not think about that particular type of case. And most of them are attorneys, whether it's prosecution or defense, that I have seen time and time again. So we're talking about people that I know their reputation, not just because I've heard it, but because they've been in front of my courtroom. I've seen them try cases. I know that they can try cases. I know that they're competent, that they took the time to investigate the case. And if two competent attorneys, unless I have some inclination or some gut feeling, something else, they know that this case is worth it. If you get to the point, unfortunately, it can happen, but if you get to the point where you feel like, I've had an attorney, and it's very, very rare, but occasionally it might happen either in front of me or another judge, where your gut is just off. If you have your gut off with the same attorney's cases, we got to figure out what's going on. Those are the situations that you might not tend to trust what is happening.
Right.
But generally, you know the people, you've seen them before. We often have some of the same, what we call local attorneys, not necessarily all Cherokee County attorneys. We have a lot of attorneys from Cobb County or even from Pickens County or Forsyth County that come over and handle a lot of Cherokee cases. Their office might not be in Canton or Woodstock, but we see them on a fairly regular basis. And remember, I have been practicing in Cherokee County for over 12 years. So I have 12 years worth of knowing the people that generally come to Cherokee. Before that, I practiced in another county. I practiced in Fulton. But frankly, there are attorneys that I knew from my Fulton County days that still appear in front of me. They were either public defenders, district attorneys, or private attorneys. And they're now either always took Cherokee cases or now starting to. I've known them sometimes longer than the attorneys that are appearing in front of me.
Yeah, that's really neat. And, again, just having that perspective, like you, I had started off, well, I guess we did the reverse. I started off as a prosecutor, and then I moved to defense. And the perspective I had as a defense attorney on these cases completely changed from the perspective I had as just being a prosecutor. And I feel that, it's such a value to be able to offer that perspective to clients, to the community when you've been on both sides, so that when you're evaluating a case, you really, you don't have a bias, that you understand, um, on a very deep level how the judicial system works, what typically happens with these cases, how the other side is thinking when you're strategizing a negotiation or a resolution. And that's, I mean, I love that you have that experience and that expertise. And I really wish it would be a requirement for all judges to have, who are sitting on criminal cases, to have that on their resume, that they've gotten a perspective from both sides, and that they're going to be looking at these cases fairly and impartially. Um, let's see, what else? What else do you want to talk? What else do you want to talk about? Is there anything else you want to know, voters in Cherokee County, about you?
Let me give a little bit of background. I did grow up here. My maiden name is Holbrook. I was born and raised here. I grew up in Woodstock. For those that have been around the county for a very long time, I grew up off what is called East Cherokee Drive. Before that, it was called Hickory Flat Andersonville Highway. The end of East Cherokee, where it hits Highway 5, but now there's a Publix, Seven Tequilas is nearby, a Taekwondo studio, etc. That intersection used to be a stop sign, but that's the Andersonville community. The other end, East Cherokee, you hit Hickory Flat, you eventually go into the Macedonia area. But when my parents moved here in 1977, that roadway had no street sign, and people called it Hickory Flat Andersonville Highway because it ran between the two communities. Other roadways didn't have names either. Our street signs, people call them what they call them. Mill Creek Road was called the rough road because at that time it was extremely rough and always flooded out when it rained. So I've been around here for a very long time. I have seen the county grow. The public library in Woodstock used to be on the corner of what is now Town Lake and Main Street. It was in a little bitty building that has since been various shops and an antique shop. That was the library. That was probably no bigger than, at best, twice my family room right now, that is fairly small. That's it. I've seen it grow from, there were no grocery stores around. I was in early high school in the early 90s when Ruby Tuesdays came into Woodstock. That was the very first non-fast food chain restaurant that appeared in Woodstock. I've seen the county grow. I came back to this county to raise my children because I wanted those values. I wanted the values of the people that cared about the community. They cared about where you lived in. They didn't care about what you did. They cared about who you were. I grew up near, like I said, the Andersonville community, near Johnson Elementary, lower middle class. When back then, Sequoia in 1990 was the third high school to open. I was entered there in 1992 when, so it was the third school year that it had opened up. I've seen it grow. When I graduated high school in 96, they opened up the fourth high school at Woodstock, and then since then 2 more. I've seen it grow from a big area, but I came back to Cherokee County to raise my children with those same values, a sense of community, a strong, extremely strong educational system. I grew up in public schools here. Now there are other great schools in the community. There's charter schools, there's private schools. Education choice is a parental choice. But I came back to Cherokee County for the education system, for the sense of community, for even though it is a very large county, when you compare it to the other 158 counties in the state, it doesn't feel like a large county. It still feels very small. When I came back, I lived in Great Sky for 9 years, and then my family and I bought 5 acres in what I call Upper Ball Ground, 15 minutes north from downtown Ball Ground, off of Revis Mountain Road. The people have lived here longer in this area than I call it. We call it Revis. A lot of people call it Revis Mountain Road. It is very rural, very nice, this is the area I raised my children in. This is the area that I have chosen. It's also the area and the entire county that I like to give back to, because I came with a lot of strong values. My Facebook friends, my community friends, they're people I grew up with. They're also my teachers. One of my Facebook friends is my kindergarten teacher. I have my high school guidance counselor. I have some of my high school teachers. I have a strong sense of community, and I want to give back to the community that raised me. When I moved here, I wanted to come back and work here. I wanted to be not just someone. Cherokee County has historically been a bedroom community. The school system is the largest employer. A lot of other people go to other counties to work. That's certainly fine, but I wanted to live and work in the community that I was raising my family in.
Right. It is really a unique county. I mean, the schools are great. We love it here. And it's just a very warm and welcome, and really, the local businesses are amazing. Like, I love our local businesses that we have that here in Cherokee County. I did want to ask you something else though. So for people who may not know, there's 3 state court judges, right?
Correct.
And you're the only female.
I am the only female, yes.
Has there been a state court female judge before?
No. Until 2000, my predecessor, Judge Gober, was the only state court judge. At one point in time, Cherokee County, which is now one county judicial circuit, used to be with other counties. For a time, he was a state court judge in 2 different counties because they were connected. In the year 2000, Cherokee County added a second state court judge, and Judge Alan Jordan took that position. 10 years ago, in the fall of 2010, third state court position was open, and that is the position of Judge Dean Morris. So yes, I was the first state court judge. Judge Mackley in Superior Court was the first female Superior Court judge. Now I have always, there's always in the time that I have practiced here been a part-time magistrate judge that is a woman. The 2 judges that presided in probate court before the current one, they were both women as well. But in terms of state court, I am the first woman who served on the state court bench at Cherokee County.
That's really neat. That's a huge accomplishment, really. I love speaking with attorneys who, even male attorneys who experience women entering this profession and, breaking ceilings. And it's I never vote for anyone based on their sex, but it is incredible because that with that obviously had to come some hurdles, right? It's anytime you're the first of something, you're creating a new path, and it's really inspirational to see what you have done and the way that you've taken this on, and you're addressing issues so that our community can be protected. And I love that you're open to getting beyond the status quo and really looking at how can we really impact our community and really keep us safe. There are going to be people who commit crimes. We're not immune from that, obviously. But the way that the approach that you take on these cases, I think, is going to really have a momentous impact on the community over the next few decades. We're going to see with more treatment, with even just having that authority figure take a moment and say, I believe in you, don't be in front of me again, get some help. I'm going to make sure you get some help. You're going to be really incentivized to do that. And if you don't do it, we've got space for you at the jail. But I think people need that, because you may be the only person in their life. And it's hard to imagine this, but for many people, you may be the only person in their life that cares, even if it's just for that morning in court when you're accepting a plea. And I love that you take that responsibility and you grab it and you own it. It's incredible. Thank you so much for talking with me today. I think this is going to be really valuable for people who may not have a lot of interaction with state court. And
Thank you.
I've already voted for you. So you've already got my vote. My husband's already voted for you. Of course, we're encouraging all of our friends. I think it's really important to keep good judges in Cherokee County. You know, I hope not, but I do have a 15-year-old, and she is going to be driving on these streets eventually, unless they can come up with a self-driving car before then and I can afford it. You know, I think it's important that I know that the people that I've elected are really going to take a moment. You know, if my daughter doesn't wear her seatbelt, gets a ticket, or you know, they'll take a moment to really make sure and invest a little bit of time to make sure, in addition with me and my parenting, but to make sure if she were to get in trouble, that hey, let's redirect you on the right path.
Speaking of your 15-year-old daughter, most people, you would know this, but most people don't realize when you're 17 in Georgia, even though you cannot join the military, you cannot buy vote, and you cannot buy cigarettes. You are a adult for criminal purposes. So I see people from 17 and above. So when you're thinking about, when a parent is thinking about, okay, well, my kid is a minor, I can keep them on my insurance, I can still write them as a tax deduction. At 17, they're not. At 17, if you missed your September 1st birthday, you're only going to be a junior in high school. So you get a speeding ticket, you're going too fast, whatever the offense, you're going to be in one of our state courtrooms.
Right.
It's not. That's one of the greatest things I love about state court is I'm going to generally see the people that I would otherwise see in public. I'm going to see somebody's child who's 17, 18, 19 years old. I'm going to see somebody, sometimes I went to high school. I'm going to see somebody who's on a PTA board. I'm going to see someone who's a parent. I'm going to see someone who I may see at a gymnastics meet, a ballet recital, scouts, at a basketball game or a baseball game. Not always, but generally the crimes we see are ones that each and every person in the community may commit at this point in time. Prosecutors generally ask jurors who here has never gotten a traffic ticket. Very unusual that anybody raises their hand.
Right.
And at some point, you may see the inside of a state courtroom, not ever thinking that you would. You may pick up that cell phone that you're not supposed to. You may have forgotten to renew your tag and get an expired tag ticket. There are a whole host of reasons you may see the inside of a courtroom.
Right. Yeah. I mean, probability wise, I mean, it's probably the most likely place where you would have an interaction with the judicial system.
The only one more likely would be probate court, because probate court deals with marriages, birth certificates, death certificates, estates. That's the only place you generally, at one point in time, you or your family is going to end up in probate court, generally probating someone's estate. But otherwise, in probate court, the most likely place you're going to end up is state court.
Right. That's true. Have you noticed any trends over the 7 years that you've been on the bench?
In terms of DUIs, we've seen a lot more prescription drugs. They are never generally, not always, but generally, they're from people that had no idea how the impact was.
Right.
A lot of people think, my doctor said it was okay to take this. I may have multiple different doctors subscribing multiple different things, not realizing how they interacted, not understanding body chemistry, that it may have been fine to take it yesterday, but something in our body chemistry changed and it impacts me differently. We've seen a trend lately of mixing of substances. Usually it's a prescription drug and alcohol. Neither one may be excessive consumption, but sometimes when you mix substances, you get a reaction that you never anticipated, particularly if you had mixed alcohol, which is a depressant, with some kind of central nervous system stimulant. Your body just doesn't know what to do, doesn't know whether to go up or down. Sometimes when you mix two depressants, for instance, Xanax, that a lot of people take for anxiety, it's designed to kind of mellow you out. Well, alcohol mellows out people as well. So if they take both of those at the same time, and we're generally talking about people who are not abusing their prescription drugs, they're taking it exactly as prescribed, they're not understanding the double impact that has. We've, of course, when the new hands-free law came into effect, we saw that a lot. Those are tapering off. It depends on how things are going in the economy. Sometimes we see more theft cases or more related to finance. Now that the economy's picked back up, we haven't seen that as much. However, with this pandemic, we're going to see a lot more people that cannot pay their fines because people have been out of work. Even someone who remains employed, say as the waitress, they haven't had tips. And when you look at the restaurant community, even if they're open now, they're not open at full capacity. You have a lot of people doing takeouts. They don't tip on takeouts. So we're going to have, going forward, a lot of people who may not be able to pay their fines. If I have no idea what the pandemic's going to do, I do give community service for people who can't pay the fine. But going forward, if there's a second wave, and I have no idea, I'm not making any predictions, but just a what if you've got your children at home because they can't be in school and you happen to get a traffic ticket, you don't have time to do community service because you have 3 or 4 or 2 or children in tow. That also means if we have you in court, depending on where the judicial emergencies lie, you may have your child with us that would otherwise be in elementary school or middle school, might not have a chance to leave them. So we see changing dynamics that is with trends that are kind of out of our control. Sometimes the sheriff, over the years, the sheriff has had a particular task force for traffic enforcement. When that happens, you see a little bit more traffic enforcement, simply because not the sheriff's office isn't enforcing them, but they have special grants that give them more availability to do that. So it comes and goes. It also comes and goes depending on the month we're in. So if it's in January, it's very difficult for people sometimes to pay their fines because they have just bought Christmas. It comes and goes. Each person is different, but there are definite trends that you can see over the time period.
With the pandemic and all the unemployment that our country is facing, our community is facing, are the judges around Georgia, are they getting together and coming up with a plan on how to handle these fines?
We haven't talked about fines in particular because we are starting to figure out how we're even going to manage getting people into the courthouse. We typically, before the pandemic, state court runs arraignment once a week, 3 times a month. So 3 days of arraignment for each judge, and they're all on the same day. We may have 80 to 100 people, sometimes it's less, but 80 to 100 people on a calendar per judge. Some of them have attorneys and they waive their appearance. Some of them pay ahead of time. Some of them choose not to come. But even if you had, say, 65 people in the courtroom, times 3, we're talking over 180 people that need to come in the courthouse for a court date. That's just the people who are charged. It doesn't count if they had a driver with them. If they're a young adult, they might have brought a parent. That is a lot of people that we process on just one day. With the pandemic, we can't do that. To open back up, we've got to meet 6 feet between people. We have to check temperatures. We have to do masks. We cannot have that number of people at any point in time. Even doing a jury trial, we don't have boxes big enough even in the largest courtrooms in the courthouse, a box big enough to hold jurors. You have 6 jurors generally. That, no jury box will hold 6 jurors 6 feet apart. So we haven't even begun to talk about alternative ways to handle fines because we don't know quite yet how we're going to get the people in the building
Right.
with safety concerns. You still have, even once we open back up, even once we have safety concerns in place, there are still going to be people that are terrified to come out of their house in the first place.
Mm-hmm. Yeah, I mean, it's going to be interesting. I know here with our firm where we're doing divorce and custody, we have been able to do some Zoom hearings to try to get these cases to move along a little bit. But here at our office, you know, we've been very concerned about the backlog that has accumulated during this judicial emergency order. You know, there are people who, you know, they really need some resolution, and it's been difficult to get that for them. We've been able to do some mediations via Zoom as well. But the thing I can't wrap my head around is how would you do a jury trial, you know, for criminal cases? How do you do that with a Zoom?
You can't. You have to judge credibility. First off, the defendant has a Sixth Amendment right under the U.S. Constitution to confront the witness. You can't, it's going to be hard for the defendant to even confront a witness. And I don't mean physically confront, I mean the idea that you're able to see, hear the witness if they're seated so far in the back of the courtroom that they can't hear. One of the things that we tell jurors in terms of judging whether a witness is credible is their personal credibility they observe from how they testify, not necessarily from the words they say, but their demeanor, how confident they appear when they speak something, whether they mumble, whether they, you know, are not sure, whether they, you know, we all go down in our normal lives and we look at someone and we make an opinion on their credibility. Jurors do the same thing. It's going to be very difficult to do a Zoom trial that way. The state court judge bench has done as many Zoom hearings as we can right now. Generally, they've been either motions to modify bond conditions, or mostly they have been pleas or revocations. But they have all been, with very few exceptions, people who have an attorney. Because when you don't have an attorney, it makes me very difficult for you to be on a Zoom hearing, for me to even be able to get contact with you to tell you I need you to be on Zoom. But usually in a courtroom you would talk to or have the ability to talk to a free attorney that day. That is very difficult on Zoom. There are breakout rooms, etc., but that's going to be extremely difficult.
Right.
We are trying our best to move the cases along as we can. By the time the statewide emergency is over next month, we'll have about 3 months worth of cases. Luckily, because there has been a lot of people that have stayed and put place, they have sheltered, there's not as many new cases coming in.
Right.
People aren't driving around, they're not, you know, speeding, they're not going to stop at a stop sign. There's not as many cases coming in.
Right.
So there isn't as quite of a backlog as you would think, but we definitely have 3 months worth of practically no court that we'll have to figure out how to go forward. Of course, we can't just return, as I said, to a normal schedule and haul people in the numbers that we have been accustomed to.
Right. I think your screen has frozen a little bit.
Oh, yes, it did. I don't know. Hopefully the audio came through, but yeah.
Yes. The audio is still coming through, just frozen. I'm going to
just have audio.
Okay, so being that Judge Homeyer is way up in Ball Ground, it seems that the bandwidth is a little short. So she's still on here. It just, the video will not come through. But I just wanted to, you know, wrap it up and say, you know, again, just thank you so much, Judge Homeyer, for all that you have done and all that you will do for our community in your position as state court judge. we are, you know, I love being able to check that box next to your name. I was very proud to do it. And, you know, if there's any last words you'd like to say to voters.
I want to thank y'all for going through a difficult election season with us. I know it's been very confusing. Georgia has, you know, after in the last 8 years, split the presidential from the primary, from the other primaries. So already you have to go and vote twice, which I know can be frustrating for voters. Then we moved the March presidential into May. It's confusing and frustrating. Then we moved the whole thing to June. But these elections are very, very important. It's not just because it's a judicial race. It's local elections are the first thing that impacts you. Yes, the presidential policies impact you. The governor's policies impact you. But what impacts you first is the more local. Your city council, if you live in a city, your county commissioner in the county, your judges in the county, your state representatives, they impact you the first time. Even your tax commissioner, it's your county's tax commissioner. You're making sure you pay your real estate taxes and get your tag with. Those are the people you interact with the first time. It's very important to vote in local elections like mine, because that's where your initial interaction with government is going to be. So I thank all the voters for understanding why we had to move the election. Please do make sure you vote. Early voting is next week, Tuesday through Saturday. It's also the week of the 1st through the 5th of June. Then the next time will be on the actual election date on June 9th. Also, make sure that you understand where your polling locations is. Some of them had to change very late in the game because of the schools. Some of them were at schools, now they have been moved. You should have gotten an update, but if you did not, make sure you know exactly, if you choose to vote on June 9th, where your polling location is, because of COVID-19, the elections office did have to move some of those. Please make sure you do that. If you voted, if you have an absentee ballot and you'd rather vote in person, that's an option. You just have to bring your ballot with you when you go to vote. It's easier if you do that in early voting at one of the two locations, which is the South Recreation Annex in Woodstock or the voter registration office in Canton. They ask you to do that because that way they make sure no one else is using your absentee ballot. If you didn't request an absentee ballot, please just make sure you vote, because you do not have a say-so in my race or in any other race if you don't vote.
That's right.
So I greatly appreciate it, and I ask for your vote on June 9th.
Excellent. Thank you so much, Judge Homeyer. Really appreciate it. And hopefully we'll be celebrating your victory soon.
All right. Thank you. I appreciate it, Sarah.